Skip the green card backlog with EB-1C. Today, we're diving into an important topic that affects many hopeful immigrants, the green card backlog, particularly for EB-2 and EB-3 visa applicants from India and China. Understanding the green card backlog. The U.S. immigration system sets annual limits on the number of green cards issued. No country can receive more than 7% of the total number of green cards available each year. The law allows flow-downs of unused visa numbers from certain categories to others. The U.S. State Department publishes a monthly visa bulletin, which provides the latest priority dates which assign each applicant's place in line for a green card. Applicants must monitor this bulletin to understand their position in the queue. Due to the high volume of applicants from India and China, particularly in the EB-2 and EB-3 categories, a significant backlog has developed. Impact on Indian and Chinese applicants. Extended waiting times. Applicants from India and China face a much longer wait for green cards compared to other countries. This is due to the high demand in the per-country quota system. Career and personal impact. The backlog can affect career progression, family reunification, and overall stability for applicants and their families. Uncertainty of H-1B status. Most primary applicants affected by the backlog are on H-1B status. This classification ties the H-1B worker's legal status to one or more employers, which can hamper career mobility. Worse, traveling while on this status can cause anxiety due to the risk of visa stamping rejection at overseas consulates. Worst of all is the risk of age-outs. Dependent kids who cannot adjust status with a parent by age 21 are left to find some other status, such as F1, H-1B, GC through marriage, etc., or else leave the country that they consider home. The Child Status Protection Act, CSPA, helps with age-outs in some cases, but is largely useless for backlog dependents. EB-1C, an underutilized alternative. While Indian-born and Chinese-born nationals can currently expect to wait decades for a green card under the EB-2 and EB-3 routes, the timeline is much faster with EB-1, typically a couple of years. The EB-1A and EB-1B categories, reserved for superstars of industry or academia, are usually out of reach for most people in the backlog. But EB-1C could be a viable alternative for many backloggers. The EB-1C immigrant visa is for applicants who will serve as managers, executives in the U.S. and who have been employed abroad in a managerial or executive capacity for at least one of the last 3 years. The foreign employer must be affiliated with the U.S. employer according to precise rules regarding corporate ownership. Generally, the manager-executive role should involve managing a dedicated team of professionals, both in the prior overseas position and in the future U.S. position. Dedicated team members can be working at any affiliated location worldwide. There is an option for functional managers, who don't manage team members, but the risk of rejection is higher with that option. Why this option might work for backloggers. Most backloggers have been waiting many years to acquire permanent residence. This also means that most of them are relatively far along in their careers and either may be working as managers now, or may be qualified to take on managerial jobs. Also, given the global nature of technology and the advent of outsourcing, many employers have foreign offices that could support a multinational transfer. Thus, backloggers should consider whether their employer would support a multinational transfer with an EB-1C filing in mind. There are many requirements and contingencies, so this option requires careful planning. A tough decision. For backloggers who are already well settled in the U.S., with children in school and other commitments in the U.S., the prospect of transferring overseas for 1 year may be unwelcome. A complicating factor is that even despite the best preparation, some EB-1 cases can be denied for various reasons. Still, the sacrifice involved may be worthwhile for backloggers who want to avoid the limitations of seemingly perpetual H-1B status and the real risk of age out for their children. Congress has had many opportunities to reform the visa allocation system to alleviate these backlogs, but has dropped the ball every single time. While backlog reform would be most welcome, backloggers should weigh their options and consider the real possibility that no backlog reform will pass in the near future. This is particularly true given how politically charged the topic of immigration reform has become in recent years.
If you would like Tiwari Immigration Law's help on your immigration filing, please email us at info@tiwari.com. Our attorneys are licensed in New Jersey and represent clients on immigration matters in all 50 states. This video is for informational purposes and should not be considered legal advice. Speak to an immigration attorney before applying this information to your specific case.